Yeah. Thank you, audience, for your engagement with us so far. We also have one panelist, one more panelist in this session, Zameer Nathani, Group General Counsel, CarDekho Group. He's had some urgency, but he's coming he's coming in the next 10 minutes. So we'll look forward to joining him as well. Allow me to thank our august panelists, and we would like to start this with Lorenz. It's a very important issue today in the realm of arbitration, and that is how should one go about protecting the IP rights. So if you can just walk us through, I think you had a very detailed case studies. If you can just walk us through the case studies that you have done personally, it will be great. Yeah.
Infringement case of the MP3 technology. As you may know, my former business professional time has been in Fraunhofer. This is the infringement case in the US with the highest claims ever. It's 1.6 billion. Interesting. I have made a publication which is available for you, so therefore I cannot come to this now. The second is from the pharmaceutical sector, the German inventor of the stents, you know, in the blood court, and interesting also. But you may also see that in the net and in my publication. And the third one, I think this is an interesting. We should go there in 5 minutes and see what the actual things are really important and what we shall have in our arbitration litigation cases in the future. I think this is of valuable information. These 3 actual cases, the last of the upper of the last year, have been taking place in Germany, and they were all of high damages and of high injunctive relief claims in the automotive industry caused by communication companies and by patent owners of the so-called computer integrated patents. As you know, and I make along, you can read that. They are all about production bans or injunctive relief or something like that. What is a computer integrated patent? As you know, as experts, most patents nowadays are applied as computer with components of software, not only the patent. The legislations are different, but all is the same. If they are attacked and if they are infringing third-party rights, this is not anymore like a patent with a clear description. It is with a software, and the software is much easier to be violated and to be attacked than a patent. As you see it in this graph, this is the theoretical basis behind. And what is important for avoiding such infringement cases is internally in the companies to be compliant and to see that they are not originating a problem with that. You should have something like an analysis matrix there. Are there third-party rights? Do we have discovered them? Have we seen them right? And what do we have we made to make this patent safe, which is much more difficult, as I mentioned before, with these parts of patent. I also have an article for you, which is quite new from last year in Les Nouvelles. You will have access to it if you want it, or I send it to you. And So you must decide in time. If the infringement case is there, then it's too late. If the claim is there and you are facing a production ban or something like that, then the economic damage is already made. In Germany, this is problem is now well known. It's not only Germany, it is worldwide, but not all the economies are taking care for this. In Germany, we have a standard for this, establishing rules how to avoid patent infringement and how to make the patents and the other intellectual property rights as safe as ever possible. You may also inform you about this. I cannot deepen it by time. I only want to say once, patents are really important, and patents are still always the most safeguarding for a technical solution. But this is often overestimated in the economic situation, and they do not cover all patents. Cannot cover all claims or ideas or our business interests. So you should decide early whether to patent, and if to patent, how to organize it and how broad and how intensive it shall be. And this must be a co-production between technical people and lawyers, which makes it not easier. And it is really recommended, because this merge of technical and legal facts and interests is so difficult to make a qualified arbitration in your contracts and in your strategies, which is the topic also of our meeting today. And I have also a bit experience of that. Whether it's the next, where you can see the most important arbitration courts in the US, China. In India, I found the MCIA. I have no experience with them. Happily, I have not, but I don't know what it is. I have some experience and some knowledge about the WIPO thing, the WIPO arbitration, and I think the ADR processes, which are known for you as a matter of fact, are very interesting to solve the problems, and we should take them into account. Again, I repeat, to merge technical, economical, and legal interests. This is the most important thing at all. You see here the two kinds of arbitration, the determination expert and the arbitration, expedited arbitration of the WIPO to find to a solution. Which you choose and how you do it, it depends on the case. There is no one fitted. It's all that is clear. You can see that. And what is a fact, you can see the statistics is published also last year from the WIPO, that the cases are really increasing, and that has its reason also, because they are mostly more streamlined than the public courts can be. The judge is not here, so she would not forgive me, but litigation often in technical, the cases I showed you in the beginning were between 5 and 8 years long. The expenditure and the lost money for the company is extreme. We must try and find strategies in the companies to avoid this. This is my recommendation for you. And then I looked up also for this discussion today, the arbitration courts. Let's see what we have. I found this all in India. You may have an idea about what is to do here and which you prefer, but I think we should follow the WIPO example. I'm not a PR agent of WIPO, but I think these are really good examples for it. What is the conclusion of my short speech? It is to say you that in technical respect, often it is difficult to differentiate with the legal legal requirements of contracting and patenting. We should avoid long expert discussions with high costs and often with no practical solution. And don't forget, in IP questions, the time factor. A patent is 20 years, the copyright longer, but in the time going on, it loses its value very fast, and the legal method of interpretation often have their limit in technical things. So thank you. I was very brief. I regret that, but we can discuss more of this aspect. I hope I have introduced to you a bit lively. Thank you.
Thank you. Thank you, Lorenz, for setting the international context. Yeah, and that too in a very limited time, so to say. Thank you so much. So while Lorenz has given the context, the international context of the IP rights, I'll quickly ask Chitra to give the Indian context of the same subject.
Thank you so much. And once again, good morning to everybody, and thanks a lot to ET for having me here. So today, I think I'll just talk a little bit more on follow up on what Lorenz just said from an international perspective. I represent Philips, but again, my opinions here are my personal, not my company's. So it's a company highly invested in research, highly invested in R&D, a lot of time spent, energy, money, in developing a lot of these innovations. So following up on his queue on SEPs, we are perhaps one of the largest filers of SEP in India. Currently, even today, in the matters that we have in the court are perhaps more than anybody else who has there. We are invested in Indian system. We believe in the Indian system, and we have spent a lot of time and energy on litigating in India. We have, unfortunately, matters, I know the court systems are evolving really well, and thanks to Pratibha ma'am and a lot of people like her, but there are matters which are older than 10 years in the court, so which is really not a good situation, the judicial system sometimes. But we still have faith, and we are hoping the system will improve. Then talking about arbitration, let me talk about how it's evolved in India to the extent I'm aware of, is that right from the Ayasami case in 2016, where it was defined, what could not be arbitrated was perhaps decided in that case. And it was thought at the time that, as also defined in the Arbitration Act itself, that a right in personam is probably more amenable to arbitration than a right in rem. Further, in other cases, the Boone case and then with the Adrolia case, it's further been defined that probably IP matters can be litigated in India, but so long as it's a part of a contractual obligation where it's been agreed that arbitration is going to be the method of going forward. Still, I think as a country, I feel we can probably explore it because it can be a speedy way of adjudication. As a company, I believe we have tried it a few times, but there are shortfalls, even internationally, because arbitration is behind the walls. Not everything is very open. Everything is not known. We don't know the results. And the worst thing is that if arbitration fails for some reason, and not everything in an IP matter can be arbitrable, right? There are only aspects of it. So you will have to, again, go back to the court for the rest of the matters. So it's still incomplete if you go to arbitration. Secondly, then, it has to still be a part of a contractual clause. If it is not, I think even in India, it is not probably something you can arbitrate in that sense. The question about India also about, we probably don't have the well-defined framework as yet. One is the framework, one is the legislature, trained people. The cost is still very high, and it's not well-defined. So I think those are the aspects if we can address it as a country, and then maybe we will have a better solution. Maybe speedier adjudication, especially even for SCPA matters, it may be the forum to go, but I don't think at the moment we are ready for it.
Okay. Zameer, would you have any comments to make on the IP litigation per se specifically?
Hi, good afternoon everyone, and thanks ET for inviting me. On the IP litigation, we've been seeing it for the last 20 years. You had some of the great cases which have happened, and during the course of discussions we will cite that also. One of the famous examples what we all remember is on the royalty-free licensing what we required when the COVID vaccines were out, all right? That became a WTO issue and then countries took it up. In India, I think we have improved a lot from the days when I was representing LG Electronics for registering their intellectual property rights in India as a power of attorney holder from Korea. I think the IP litigations would take a lot of time. Delhi is still preferred as a IP court jurisdiction. And probably the time and the intellectual the decisions what we are seeing at the day today. Justice Pratibha Singh has been one of my mentors throughout the years. I think there is a drastic change we have seen in the IP regime itself, all right? So there was a forum of adjudicating IP disputes where Justice Ramanna was there, Justice Pratibha Singh was there at that point of time. So I think there has been a crusade for last 2008 onwards, aggressively on registrations of IPR. I've seen IP disputes ranging from, so I've worked also with Ekta Kapoor Balaji Telefilms, and Dirty Picture was one of the movies which somebody wanted to replicate. So we are talking about patents. When I was registering patents for Eureka Forbes, the AquaGuard, what you use in your house, LG Electronics, and also the entertainment industry. I think there is a drastic change which I have seen in terms of the reduction of timelines, in terms of the quality of judgments at the moment. That's my take on this.
Okay, Zameer, that's a very comprehensive and overview take that you have outlined. If I come to Lakshika, you, and talk about the IPR arbitrability, can you share your comments on the arbitrability of the IPR?
Sure, thanks. So let me, listening to my predecessors here, there's something that crosses my mind today. In around 2016 or so, the Chief Justice of the Singapore Supreme Court was addressing an audience for one of his, informal meets. And that was Justice Menon. And he said that, we all interpret ADR as alternate dispute resolution. Perhaps it's time we should start looking at it. In fact, that's what he recommended very strongly, is to look and read ADR as an acronym for appropriate dispute resolution instead of alternate dispute resolution. And the reason for that is, and I'm going back to your question where you talked of whether or not IP disputes are capable of being arbitrated upon or not. And earlier we heard of in rem and in persona rights. And I think throughout, if you look at the case laws from the Indian courts, the issue has been very simple. If we go back to the intent of all IP laws across board, across the globe, they are the rights that are granted exclusively on the creator or the inventor to the exclusion of rest of the world. So as an IP owner, you have the rights to exclusively do certain things, which means that others have a negative impact because of that. And therefore comes in the concept of in rem. Anything that impacts third parties, anything that impacts public at large. So throughout the case laws we see, whether it is in 2011, Booz Allen, and going on from there to all the way to the Hero Electric Vehicles case from Delhi High Court, we've seen that the issue has revolved around whether the IP dispute which is being contended to be arbitrable pertain to a right in rem or in persona, and IP being also a commercial right. Lot of times we've seen that there have been pro-arbitration judgments, such as the Eros judgment from the Bombay High Court, where it was said that the impact of whether it is an IP infringement or not is clearly only on the defendant, and it does not impact in rem rights, and hence the dispute was held to be arbitrable. So I think the key question lies around, and I think Vijay earlier, which was also mentioned by Chitra, is it laid down the fourfold test, of whether or not disputes can be arbitrated upon, and it's a good benchmark for considering all IP disputes. Of course, in Delhi we've had the, as I mentioned, the Hero matter. But again, this is India. Now, having said that, I would also like to point out that also in other countries, and I can speak right now only for the US, we've seen that if the courts have held, whether it was in the matter of, let's say, an old matter of Federal Corporation, which is a landmark judgment, the courts have held that if the matter is such that it impacts the public at large, it could be a matter which is tortious in nature, or which has the capability to go beyond the impact to the defendant, that matters cannot be arbitrated upon. And I think we pretty much fall in line with those global standards, because we also are in the Indian judiciary looking at matters on a case-by-case basis. It will totally depend on the circumstances if we can arbitrate or not, depending on what kind of matter it is. And that's, I would say that's how we've been managing it in the country, which is nothing different from what other countries are doing. Whether it is the UK or the US, we are pretty much similar to what's happening there.
Okay, so certainly it is a matter of dispute whether it can be arbitrated or not. Let me come to Ajay, you. The metaverse world is a buzzword today, and how would you see the strategies being framed by the companies to sort of protect the IP rights in this regime?
Yeah, thank you everybody, and thanks to ET for having me here. And my views are personal as given by all.
Ajay, can you, if you can hold your mic closer to you?
Yeah, okay. So my views are personal as standard disclaimer. So let me add what Lakshika has said, and then I'll come to the metaverse. So, as she was talking about the RAM and persona, so basically it's all depend upon the contractual relationship. For example, I give you a very small example here. In a license and technology transfer agreement, if there are no payments are received in terms of royalties, so the matter can go to an arbitration. But if licensee wants to object on the validity of the patent itself, so that's a right in RAM. That part will not go into kind of arbitration. So it's basically the type of IP and the contractual relationship there. Another example I can add on in that in most of the agreements in IP matters where confidential matter like unregistered IP, we call it trade secret, there the fastest remedy is the injunctions. And now for injunctions, if we put everything under the arbitration, the other party can always claim about arbitration first. But the relief is required immediately to stop the, that information to spill over. So we can frame the things like that we can put that out of the ambit of the arbitration, and both the parties are free to the court to take the injunctions very quickly to stop the loss of the confidential information. So this is on the basis of the need, what type of agreement we have, what is the type of intellectual property involved in that. Based on that kind of strategy can be formed about including the arbitration or what things are to be kept out of the arbitration, but we can have that. And then, of course, my colleagues have described about the basic legal precedences over that. Now coming to the metaverse, basically, so it's a lot of talks, and what metaverse is basically is everything is virtual. So we have some ghazals like, so what I say कि सब कुछ धुआं धुआं है, कुछ नज़र आता नहीं है, लेकिन सब कुछ दिखता ज़रूर है. तो सब धुआं धुआं है, that is the metaverse. And in metaverse, basically everything is virtually, so somebody is creating something. Now for creating something, what we require is we require some technology. The technology will be, protected by the patents, and in patents it is not just the computer related inventions we call CRI, but it will also be a lot of AI, virtual reality, augmented reality, that kind of innovation will become and protected through the patents. And then further to that, there will be little of hardware, because lot of equipments will be required when we want to see something in virtuality. So those equipments, hardware will also be basically protected. Then of course, when we go there inside, we will see so many things, so many marks, everything. to recognize who is providing what, who are the service providers, who is the, this product providers in that, even in the virtual world. So trademarks also are required, and there the very important thing is the sound, because you are not only seeing but you are listening also. So there the sound trademarks will also become very important, and in future I am thinking of even the smell trademarks will also become very important, because somebody will think and say, okay, you are in a mall where you want to purchase something and you want to smell the vegetables or things where you have that kind of a feeling. So smell will also come into the picture, and you will have trademarks there. Then the shapes and the outlet where you want to be like that. So those things will be protected by the industrial design, the shapes and the features there basically. And of course, whenever you're entering in a virtual reality, you require a domain name that you entered in a correct IP address and you are not gone into a wrong addresses. And of course, if you have to do the payments there, you require Mastercard.
Chitra, would you like to have some views on metaverse?
Yeah, I'll just add to what he articulated so elegantly. So, see the issues with metaverse, I say it, the way it is, it could be many issues, I think, in addition to what he just said. There could be situations where you create an avatar with a trademark product, or you create something else with a product, and then somebody else owns trademark for it, or you could do something else virtually online. You're displaying a product, or you're displaying something on the virtual platform, which is a product which is somebody else's trademark. I don't know how blurred that whole situation is and how far it can go, because it can be quite confusing, and I think the issue right now is the customer doesn't know who owns trademark for what. And then, nor does the company probably realize that they're using trademark product, because all that they're doing is selling the product in their own platform. So does this become a trademark violation? Maybe it does. Does it become a copyright issue? Maybe it does. So it kind of challenges, I think, for an IP attorney, if you had to advise the client on this. I think there are two folds to it. One is, an advice for a company that holds these IPs, an advice for the company that is going to use these IPs in an online manner, as an avatar, or in any of these different ways. It could be a game, for example. It could be a game based on a movie. There are a whole lot of issues that again pop up. So I think it becomes important then to consider IP as a bundle of rights, just my view, that you don't just consider it as one form of product, and then you could further look at it as a trademark, copyright, and trademark further go into the different sections. Do you just cover it as a product? Do you cover it as a computer thing? Do you cover it as an animation? There are different sections for each of it, and then the online platform. So it becomes much more, I think, expansive for an IP attorney, especially or an in-house counsel, to look at how do you protect this right. So very challenging, but also very interesting, and also adds to the cross-border aspects of protecting a trademark or a copyright, and that needs to looked into, I think.
Okay.
Manu, I would like to add to that
sure.
on the metaverse. So, because we live in a world which is very seamless these days, and probably not so much on this side, but surely for our kids growing up in the age that they are, it is almost a seamless world for them. And I think because we do business in this world, it's important for us as in-house counsels now to, when we look at our IP strategy, to also factor in these other formats, whether it is metaverse, whether it is any other newish technology. Ajay mentioned something around artificial intelligence and how that could be used to create works. And we are all talking about generative AI these days within companies and outside and everywhere in the media. Of course, if we talk about the case laws, they've been limited, and it's been a very clear position if you look at it, in the one case law, which is Dabus, which has gone around the world, I think, except for South Africa, nowhere else. A sole AI invention was, recognized as patentable. It had to be coupled with a human, to be subject of patent. But even beyond that, when we look at metaverse, I think I would like to highlight a couple of interesting cases here. And these cases are not even pure metaverse that we're talking now, but slightly predate that. Let's say I'm talking of the video gaming times, when in the courts in the US, we've seen that the defendants were able to take plea of First Amendment, and the courts held that, just to give you an example, a very famous saxophonist had some interesting dance moves, and these became very viral and went all over the internet. These dance moves were then copied by Epic Game into one of their games called Fortnite, where there was a player who used to perform similar dance moves. And when the actual real person filed a matter in the court of law, claiming infringement of his privacy rights, his trademarks, and so on, the courts held that no, nothing of the sort happened. Because there was no confusion, there was no likelihood for people who are coming to that gaming video with the real person, and therefore the courts held sort of against the petitioner. Similarly, there have been cases where a strip club format was sort of used in another video game, and they claimed that it was an infringement of their copyright, their trademark. There was a certain logo, certain way in which they represent the club, which was used in a video game, and therefore, and there have been many cases. There have been the famous case of Humvee trucks used in a very popular video game called Call of Duty, where the makers of Humvee trucks actually claimed that there's been an infringement because their trucks have been used in the game. And they were used in a manner which was not just likelihood, but exactly the way the real trucks are. But the courts held that's all right because it's a game, and there's no way the users who are actually accessing that game would ever confuse them with the real life trucks. So if we extend the same logic to metaverse, it's actually quite scary for businesses, which then means that if my logos, my trademarks, my copyrights could be subject to something like this by parties which are not even related to my business, and they would get a free ride to my logos and trademarks and trade dress, I better construct my IP strategy keeping in mind that when I'm registering my trademarks or my logos and copyrights, I also reserve rights over these mediums, whether or not I have an impending launch on that medium. But I think it is prudent that I think of that medium now and reserve those rights. It's pretty much the same as we used to do like 20 years back when domain names came into the fray. If I want to say et.com, I would also register et.in, et.org, et. So I would register all sorts of domains just because I don't just want to block, but I also want to make sure that others don't use similar domains and confuse the public. So I think a similar strategy needs to be used for these new age media like metaverse for the trademarks and copyrights to be amply protected in those media.
Okay, yeah, sure. Sure. You are a new age company as well.
Sorry, yeah, CarDekho is a new age company. I have just one view, not very contradictory, is that I think in the metaverse and in the technology world, the ADR existed long back. If you see any website or an app today, it comprises of your terms of services, your privacy policy is there, your cookie policy, which was later introduced so that marketing emails and SMSs can be sent to you and your IP can be tracked. And then you had a copyright notice provision also, which is there, which was worked out as an ADR at that point of time because US courts were very reluctant. I mean, in 2006, if you write to Google or anyone, they would not even respond to your email. But point is, today things have changed. They've worked out a mechanism where you submit evidence, and ADR has been existing and very proactive. As early as very recently in my previous company, when Google and Apple both had issued an infringement notice to me based on complaint, and the evidence which we had defended, finally they turned around to that particular conglomerate and said that if anything more is required, you will require a court order, otherwise we are not upholding this. So I think those ADR mechanisms in the technology world and metaverse existed. We can just robust it by introducing a third party, is my view.
Okay.
I would just like to add to that. So absolutely, I think those mechanisms exist for the users, but still you need to protect against things like Meta Birkins, where somebody is copying an Hermes bag and creating an NFT out of it, and without any permissions from the original, copyright or trademark holders. I think those are the situations that are very nuanced to this medium. And as in-house counsels, our jobs are that much tougher now because we need to anticipate all of that, keep that in mind. It's not just what's happening back home, but across the globe, and then factor in how we should be prepared, or at least gear up internally to be able to encounter that situation whenever that comes up.
Yeah, in my case, it was a big music company and not a user, basically. But in that case also, you have recently a judgment of Aradhya Bachchan in Delhi High Court, which granted order against YouTube. It was a user and YouTube, and Aradhya Bachchan was a third party in that. But her IP was infringed, and you can use those judgments. That's my view.
Okay. So we seem to have quite an engaging debate between Lakshika and...
I'll just add one,
Yeah, please,
one
please,
line
Chitra,
to
please.
this. I only think that, I spoke about issues earlier, but I also realized that, it also presents a lot of opportunities. If done correctly, it could be a good monetizing opportunities and licensing opportunities to get royalties. So I think I urge you to also think on those lines, because protecting IP in certain ways, also the ways which Lakshika pointed out, in ways that you don't presently anticipate, can actually lead to monetizing opportunities as well. So.
And just adding to that, Chitra, you're right, because especially the metaverse, because it allows you now to get into areas where otherwise it would be very hazardous or dangerous. For example, there are situations, there could be deep mining areas where you can't physically be present. And if there's a technical or a glitch due to a machinery that is caused there, you could use a metaverse simulation to actually train your workers to sort of, rectify it and do things like those, which many companies across the globe, including ours, are attempting to do. So there are very positive and very, very, these are some good examples of how technology can also be made good use of.
Great. So opportunities also comes with risk, as we are discussing, and I would like to take this opportunity quickly to open the floor to the audience, if possible. If anybody has questions, please feel free to ask us. And there is a long hand I can see from a gentlewoman. Can someone please hand over that mic?
I think what you also said just now was from the perspective that I think intermediary guidelines is very innovative. I think we can use in those cases also. So the 2020, 21 or 22 guidelines which has come, I think it's very helpful in the courts of law, because that helps you to get stay orders.
Yeah, I just will add one line. I just think that law lags a little behind technology in most instances. It's been my constant complaint sometimes. But I think if we can think ahead of time and frame guidelines, whether it be for ADR or other things, it would be very, very helpful and save cost and time for everyone.
So Chitra, law lags behind, but not lawyers. That's opportunity for us.
Yeah, please.
Thank you everybody for illuminating us and giving us such good insights with such simple examples. That is very appealable. My question is to at the end of the companies also, and at the end of the litigation lawyers also, in this age of, when we are in the age of adopting the AI technologies and it is expanding not just as a rocket speed, बल्कि मैं तो कहूँगी मन की गति के हिसाब से चल रहा है. And the software and the developments in software is like casting a spell, as rightly said by Ajay ji, that it's not just dhua, it's like casting a spell. So I want to ask that what is going to be the impact of everybody is becoming a creator with the coming of these plugins and GitHubs, and it's diluting the actual definition of creation. So what impact it's going to have on the codified parameters of identifying a creation and then taking the take on the litigation and claiming your rights under IPR?
I'll give you one of the best examples. Yesterday I was researching on AI, and what you said rightly, so Man Ki Baat is one of the IP, and you said Man Ki Gati, all right? So that's
Right.
the next one. There are 10 AI tools. So you said, the speed at which it is going. So if you want to create viral content, use Jasper AI. If you want to record meetings, use TLDV AI. If you want to have image generator, use Leonardo AI. Create presentation, Tom. Faceless AI video, Hagen. AI product photos, Mocker AI. AI short videos, Pictory AI. All website builder, Mixo AI. So these are AIs which are going to build actually things for you. We also then put in that, who are the CEOs of the company in the world, who have also have a law degree and all that. And Chat GPT also responds to that. So Satya Nadella basically also has a law degree, etc. So this is the speed we are growing with. Today our subject is IP and ADR is from that perspective. We had interesting ADR cases globally, but somehow we have psychologically taken up IP only before the courts of law. We have not used alternative dispute resolution mechanism. There are most interesting cases, for example, Samsung and Ericsson. They both had a cross-licensing agreements. In the telecom world, how Samsung, Ericsson phones were very famous, etc. They both had cross-licensing agreements. They had royalties fixed. But then there are different jurisdictions where the royalty rates have been fixed, or there was some limitations which was coming up. They went into a dispute using ADR ICC. ICC arbitrator came out with a judgment, with an award, where they fixed up the royalty rates and this dispute could be resolved. So such fantastic examples we have got, and therefore today's the panel is to promote that where you have ADR mechanism available, use it for adjudication of IP disputes also. That's the overall take I have on your question.
Okay, we'll take one more question. I think that lady had a question.
Thank you, sir.
Good afternoon to everybody. My question is twofold. First of all, what basically are the most pressing things or lacking in the current things which are lacking in the current legal framework to actually make India an IP hub for arbitration? What do you think from your panelist view that we should actually adopt the changes to actually really move towards the idealistic IP arbitration?
Yeah, I'll probably answer that. I think I spoke a little bit about it because there are multifold issues. As I said, the case laws that have evolved right now, they say that the way it is till date, to the extent that I'm aware of, IP disputes can be resolved if there's a contractual clause which calls out and says that arbitration can be a medium of resolution. But having said that, the real question that we need to ask ourselves is, do we have the technological framework needed? Do we have the venues for that? Do we have competent people for that? Do we have the structure to do something like that in terms of legislation, a time bound? Arbitration has to be attractive at the end of the day, and I do agree that it has got maybe immense potential. But to get to a point where to do it correct, it needs a lot of efforts, coordination and efforts. We need to have trained arbitrators. We need to have trained lawyers at the end of the day to make it a success. I think if we get to that point, I do believe that it can be quite useful. But the downside of arbitration, as I've seen as somebody litigating in the patent field, is that it's all anonymous, it's all behind the curtain. You don't know what really is happening, and when you have an SCP dispute or a patent dispute, the balances are quite, if I'm a patent owner and there's a patent user and implementer on the other side, my expectation from the court or the adjudicator is going to be pretty skewed. It would be 80% of what I'm asking for, and it may not be what an arbitrator decides. So we need to have several consideration into that in deciding whether it's going to be a middle path. Is everybody going to be happy with the middle path? So I don't know if it answers your question, but I try to give you a, yeah. Sure.
So we are in a country where IP is very interesting, where Delhi High Court decided one case in a music company, and next day IPAB decided exactly opposite of that, all right? And then the matter was in the appeal, it's still in the appeal, it's not decided. We also had thoughts about specialized IP courts, because China was talking about it. We also went into that zone of talking about specialized IP courts. I think that is one requirement. Number two, the most critical issue which I see, so I was working for Raymond, and when we conducted raids, it's a different aspect. We found relatives of politicians running those businesses, etc., which is different affair. But enforcement of the IP award or IP order was one of the challenging part of it. I think in our country, where we see ADR or arbitration as an alternative available for IP dispute resolution, I think the speed of the arbitrator, one, has to be ensured. Number two, quality of the arbitration award has been very good in India. Third is the enforcement aspects. I think these three aspects, if you are able to address it, I think we will have fantastic ADR in intellectual property rights. That's my take.
That's a pill that has been prescribed by Zameer. So we'll take one more question if possible before Madhur knocks on my door. So yeah, from the gentleman.
Hi. So I've been in in-house counsel till like a year back. So my question is to all the in-house counsels. So what exactly is the role that the general counsels or the IP counsels that they play during IP litigation strategy, and does it differ when there is international arbitration?
Let me take this question. Basically, as I told you earlier also, that it's all depend upon what is the subject matter. So, it's a registered IP or unregistered IP. Suppose if it is unregistered IP, the trade secrets, the software programs, codes. So what is required is the utmost thing is the confidentiality. So how much confidentiality we can expect in a court of law, or how much confidentiality we can expect in an arbitration, which is a private matter. So anybody can decide on that. Secondly is that if we go with the registered also IP also, there also, what the intention of the parties are, and what is the contentious matter, whether it is related to the payment, or whether it is related to the technology, or whether it is related to the execution of the contract, or some plant if we are making, or we are carrying out some services. Depending upon that, we can put and decide, and of course in arbitration, if both the parties are agreed, then only we can go. In court of law, anybody is free and can go and ask for the remedy. So we decide based on the subject matter, the contractual relationship, and of course the country we have chosen, the seat we have chosen, the law, governing law we have, and the public policy of that country with the law we have chosen, and of course wherever the action has taken place, there the public policy, the law, and based on that we can choose. So there is no simple straightaway answer saying that okay, this is good and this is not so good. As I earlier said, that you can have the clause in a contract saying that okay, we are subject to the arbitration, but exceptions are namely A, B, C, D, and these are my exceptions. And why these are exceptions? Because what is the scope of my agreement or my contract decide those exceptions.
Okay, so there we will stop, but we started with Lorenz, Kaiser, and we'll give last 30 seconds to him. Please, Lorenz.
Yes, I think this is a very interesting discussion about details, but let me mention one thing again.
30 seconds.
I'm a friend of prevention, and as you know, in the moment, then you have a litigation or infringement or whatsoever, then it's too late. Then you will spend a lot of money for things which are unexpected, and you don't know what will happen unexpectedly. Therefore, I only give the strong advice to organize your IP management before this happens. Organizing means to go on a strategy for IP, whether it's a patent or a copyright or whatsoever, and be aware of this software issue in AI cases, in all the software cases. We heard it from the judge this morning. That was a very good comment she made. These new technologies have new requirements also in the legal world, to the legal counsel especially, as mentioned. And we must take into account this. We cannot use our experience of recent cases to the modern situation. And again, and then I finish it, the link and the, let's say, merging of technical issues with legal requirements and laws is a very difficult thing. The reason for it that engineers and lawyers are from their education absolutely different. An engineer makes everything working. A lawyer is telling about the rules. And the engineer, you cannot imagine how often in my profession was asked, why is this so legally? And then change it, please, that it works. They do not really see that this is a different world. And in the moment you have merged this to a strategy, then you will win. And last aspect is products, modern products, and products on the market now are complex products. They are not from one, there are 2, 3, 4. These are complex development with one or more partners. And please, like my colleague here said, see that you have the right partner and negotiate diligently. And if it doesn't work, then leave it or change the partner. As you know, to say something trivial, you know that the right moment, the best moment for a divorce is before the wedding. And if you have come in an arbitration anyway, then you should really have an arbitration agreed and not going to regular courts. That's also okay, but it takes it's time consuming, expensive, and everything else. Thank you. No.
Okay, thank you so much, Lorenz, and to each one of our panelists here, as well as to our patient audience. It means a lot.